वेलकम टू प्रिंट शॉर्ट एंड हाउस स्टूडेंट्स। स्पेशल लीगल डिक्टेशन 100 वर्ड्स ए मिनट। जिन स्टूडेंट्स का अभी पंजाब एंड हरियाणा हाई कोर्ट चंडीगढ़ का सीपीटी पास होगा उनको ये मौका मिलेगा कि वो स्किल टेस्ट दें। हम स्टार्ट करते हैं 100 वर्ड्स ए मिनट 500 वर्ड्स। बी रेडी, स्टार्ट। Believing the testimony of Srimati Kantarani, the wife of the deceased, and of Tony, the son of the deceased, and the fact that the knife recovered pursuant to the disclosure statement of the appellant was found to be stained with the blood of the same group as that of the deceased, wide impugned judgment and order dated 28th August 2004. A finding has been returned that the prosecution has successfully established that the appellant murdered Trilok Chand. Full stop. The learned trial judge has also referred to the fact that the T-shirt got recovered by the appellant pursuant to his disclosure statement was stained with the human blood, but it appears that the said fact has not been used as an incriminating circumstance, probably for the reason the group of the blood on the shirt could not be ascertained by the serologist. Full stop. At the hearing of the appeal, learned counsel for the appellant urged that the wife and the son of the deceased were planted witnesses and could not have been a witness to the crime. Full stop. To highlight the said plea, learned counsel referred to the site plan to scale as per which the spot where blood of the deceased was lifted was on the public street outside the residence of the deceased. Full stop. It was asked that the wife and the son of the deceased deposed that the deceased was assaulted inside the house. Full stop. Counsel submitted that the place where the assault took place was marked B in the site plan, which spot was in the verandah of the house. Full stop. Our attention was drawn to the fact that no trail of blood was detected from the spot mark B to the spot mark A. Full stop. A limb of this submission, it was urged that the post-mortem report of the deceased showed injuries on the chest, but the two witnesses stated that the appellant stabbed the deceased in the abdomen. Full stop. It was thus urged that it was apparent that the two witnesses had not witnessed the assault. Full stop. The third limb of this submission was that neither the wife nor the son rescued the deceased by removing him to the hospital as was expected from the wife and the son. It was submitted that this circumstance also establishes that neither the wife nor the son were near the deceased when he was stabbed. Full stop. The second point urged to discredit the testimony of the wife and the son of the deceased was by highlighting the improvements made by the two vis-a-vis the statements made by them before the police. Full stop. Thirdly, it was urged that there were material contradictions and variations inter se the testimony of the wife and the son of the deceased in reference whereto it was urged that none of them could be believed as regards the version of the crime. Full stop. Lastly, on the issue of recovery of the knife at the instance of the appellant, it was urged that no independent witness was associated in the recovery. Thus, counsel urged that the recovery of the knife has to be ignored. Full stop. On the issue of the recovery of the knife, suffice would it be to state that recoveries of ordinary knives etc. by the accused are treated as weak evidence. Full stop. Stop.